Yeah, we're sharing.
It's only in case. You want to look at it? I've looked it over.
I'm trying.
Okay, we're live.
I'd like to welcome each and every one. Do you want to say before we get started? Do you want to pray? You want to be the one to pray?
I was just getting ready to.
You thinking? I'd like to welcome each and every one to the May 26, 2016 Walton County Zoning Board of Adjustment. If you would please stand as we have the invocation followed by the Pledge of Allegiance. Tony, if you would lead us with the invocation, please.
Lord, according to the duties and services of the county, let us grant us wisdom and patience and grant those justice in these cases. Amen.
Yeah.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. You may be seated. I'd like to thank all the board members being here tonight. I think most everyone understands Mr. Art Miller has resigned. He moved from the area down to Bradenton. He served the board very well. He will definitely be missed. I appreciate his input that he contributed. Hate to see him leave the county. Sometimes he wrote things he probably should have not, but anyway, he was an asset to the county. I'd like to take and thank Carrie for being our secretary and the hard work she does.
Here, here.
Mr. Davis, thank you for being with us tonight.
Glad to be.
Are there any announcements that need to be made tonight, Mark?
Yes, sir. I have a few, if you don't mind, Mr. Johnson.
Sure.
First of all, just a quick reminder that your Form 1 financial disclosures will be due July 1. I know.
I forgot all that. It's sitting on the counter.
That's why I'm reminding you. Secondly, I've been asked in the past, I'll just give you a quick brief update. The Nipper brief, that case is on appeal to the First District Court of Appeal. Their initial argument is due next week. I believe it's Thursday. Then we'll have 20 days to answer that. The appeal, the Kaya appeal, the 250-foot buffer case, there's been a motion to intervene in that case filed by some of the folks who objected. The judge actually called yesterday to set a hearing on that motion, which, by the way, is a little bit unusual in an appeal to have a oral type hearing. But he wants to hear argument on the motion to intervene, and there was an objection filed. So that case is moseying along through the.
Is that scheduled yet, Mark?
No, sir. We were swapping dates as I left today, so I don't know if they actually decided on a date or not. Then lastly. The RFQ for the board attorney for this board and the code board, the responses are due June 3rd. We will then have a package for you at the June meeting for you to rank them. I'm going to give you a ranking sheet. And then we'll take your rankings to an interview panel that the county will set up to interview those folks. And so you'll have that input before the actual hire. And those
Who's going to be
the
the panel?
Yeah.
I tell you the truth, I haven't got that far yet, but I'll let you know.
Can we select one of the people from this board?
I don't know. I think you can, but I'm going to check and make sure. I'm not sure off the top of my head.
If we can, I'd like for Mr. Fletcher to represent us. If it's okay with the rest of the board members.
It's fine with me, but let me check and make sure there's no purchasing or, that sort of is a area of the law I have to take a lot of time with to make sure we do it perfect. So, yeah, I'll make sure. So those are the announcements I had, and thank you for giving me the time. You
representing us and Theriak's representing, there's two counsels on that appeal.
Oh, yeah, there's more lawyers than that. Mr. Kerry Parsons, on behalf of Neighbors Gibbling, filed the appeal on behalf of the staff. Mr. Theriak is going to be representing the Kaya folks, defending the action. We'll most likely, our office will join that, or whoever your new attorney is will join that. There has been, like I said, motions to intervene filed by another law firm on behalf of a couple of the neighbors that appeared. And
so they require their own attorney.
They've acquired their own attorney and will be filing, I'll assume, a brief challenging the decision as well.
There's how will the new attorney, if they come on, should they be representing, or should you say represent?
No, we'll turn it over to them. We'll make arrangements to turn it over to them.
Look it up.
Well, can anybody go to this?
It's interesting. It's an appeal. to the circuit court. It's called a petition for writ certiorari, which is an appeal. To the trial court, that sounds unusual, but it has appellate jurisdiction to hear decisions that you make. There could or could not be a hearing. By that I mean many times those decisions are made on paper. Each side will file argument, petition for writ cert, and a response. Sometimes you can ask for a hearing or oral argument before the judge. Not all the time will the court grant that. There's no requirement that he grant it, but sometimes he'll grant it just to, he or she may have questions about what was argued on paper. If that happens, I will certainly give you guys notice, and yes, you can attend. You certainly can attend. Yeah, it's, petitions for writ cert are pretty formalized legal proceedings, and they're a lot like regular direct appeals to an appellate court. But if there's a hearing, I'd certainly I'll let you guys know.
Who's the judge?
I believe it's been assigned to Judge Santuri, which is another point. Judge Santuri he's run up against Florida's mandatory retirement age for judges. Judges can only serve in Florida until they're 70, then they are required to retire. He has formally announced his retirement, and the Judicial Nominating Commission has received applications, and the governor will be picking his replacement. I understand his replacement will be in place in November. And I suspect this appeal will be done by then, but it's a chance it would not be done. So we may have a new judge by then.
Well, if he hears it, he can still work part-time. You think
He can be appointed as a senior judge. There's a period of time where he can't work, and then he can be appointed as a senior judge. Normally in this kind of transition, having been in Walton County the last 28 years, I've been through a lot of judge transitions, unfortunately. Most of the time, if it's something like this where it's a petition writ cert pending, if he's had oral argument, he will rule before he goes off the bench.
Okay.
If he hasn't had oral argument, he may not.
Thank you.
Sure.
We need to do the swearing in before you get started.
Anyone
Anyone here tonight that plans to speak before this board, if you would, please stand and raise your right hand. Are y'all going to speak? Are y'all going to speak before the board?
Depends on whether you actually hear the defrontish case or not.
Well, just go ahead, raise your hand.
Do each of you solemnly swear or affirm the testimony you're about to give before this board will be the truth?
Yes,
I do. And do us a couple of favors, you would. It's a small crowd, but just let us know you have been sworn, and it helps us to take minutes if you'll spell your last name. So, thank you, Mr. Johnson.
Mr. Carpenter.
Matt Carpenter for the Planning Department, CARPENTER. The first request is we've got a request from our attorney to continue the defranchise items that are under item number 1A and 1B.
To continue into the June.
To
what date in
continue
June?
to the June 23rd
Motion
regular
to continue
ZBA.
June 23rd.
I'll move.
Second. All in favor, aye?
Aye.
Go ahead.
Thank you, sir. We also have one more request to continue for an item that was supposed to be on our agenda tonight, but due to some confusion as to whether or not the application was complete, it did not get advertised by the county for this meeting. It did get advertised through the notices to affected parties within 300 feet and the erection of a sign notice at the parcel for a variance known as the Darren Beaujolais variance. It's project 16-005-00010. We would ask that the board grant a request to continue offered by staff to preserve the advertising that the applicant has completed in accordance with the code.
That one's not in our notes. It's not in our book.
It is not in the book, and it was supposed to be in the book. The applicant advertised. The county did not advertise.
Okay, what was the name of it?
Let me spell it for you. First name is Darren, D-A-R-R-E-N. Last name is B-O-I-S-J-O-L-I-E.
B-O-I-S-J-O-L-I-E.
Beaujolais. And I'm probably mispronouncing that, but
Sounds like a
I
wine.
apologize.
Motion to continue Rosalie
To
until June the 23rd.
June 23rd, regular zoning board of adjustment meeting.
Second? You made the motion?
I'll second.
Your second? Bill.
Mr. Fletcher.
All in favor, aye?
Aye.
Okay.
Thank you. The next item, number 2 on our agenda, Lot 10, Village at Blue Mountain Beach variance. Vivian's here and she can introduce this case.
Do we want to talk to her first, or do we want to speak with Miss, who representing the one on that one? Blockowicz? Who's here? Are you the gentleman? Come up. State your name for the record.
My name is Michael Bryla, B-R-Y-L-A.
Okay. B-R-Y-L-A.
L-A.
You are representing Ms. Mary Blockowicz.
Yes, sir.
You want to explain what you want us to do?
She has hired me as a general contractor to build her home in the village of Blue Mountain Beach. She purchased a lot sometime last year. It's a 30 by 50 lot with 7.5 foot side setbacks, 15 back, 20 front. The requirements are to build at least 1,000 square feet. We have our first floor footprint inside the setbacks. Second floor is cantilevered out 18 inches on part of the second floor and continues up to the roof. The county requires the overhangs to be part of that 18-inch setback. So we're requesting an 18-inch setback on each side so that the house can be built as designed with an 18-inch overhang.
You asking that the 7.5 foot setback be reduced to a 6 foot setback, so you asking for 1.6?
1.5.
1.5
Yes.
on the east side and the west side, is that correct?
I think it's the south and north.
North and
South and
south,
north.
yeah.
Yes, sir.
Okey-doke. And that's pretty simple, that's all you have to.
I'm just curious. This is consistent with what's been built in the neighborhood
Yes, sir.
in the same subdivision? Okay.
Yeah, evidently the county had put forth an ordinance at some time in the past year or so after she bought the property, and then didn't show up until we did the plan review through Margarden, and that's when it popped up. So
We're gonna listen to the county and we'll give you the opportunity to come back
okay, thank you.
before we close it. Ms. Vivian?
Good evening, Vivian Shabel, Planning Department. And basically, you've seen 3 cases from the same subdivision, same size lots in previous meetings. And really, I've included, I think, an aerial in here as an Exhibit D. You can see right across the street to the west of them the size of the homes, and they are very tiny. I think we have approved, the county had approved several of these before. We came with a determination from Wayne Dice regarding the covenants and so forth. The ones that were allowed to cantilever actually added some design value to the home, and I think it's just a continuance of what we have allowed, and it keeps with the existing pattern of the development there. So,
Did they have design guidelines or something that stated they were allowed to encroach as part of their covenants and restrictions, that they would be following otherwise?
I'm not positive of what their covenants said. If they did allow it, I wouldn't want to say because I couldn't be accurate on that, but that's the way the pattern had developed over the time, and just by the sheer size of the homes, they look very awkward sitting there without any kind of design.
So how many were built
I'd have to look at the plat in the aerial to see how many, or actually do a drive-by. They are spotted out throughout the neighborhood on the larger plat, these various types of small-sized lots.
I think we probably have 3 that show in the aerial photo. That's Exhibit D. I think there are some that are further to the east as you go back down the hill towards County Road 83 that were built shortly after this property was platted in mid-last decade.
I guess my question is, when we've done these in the past, I know that this one had come up, that one of these had come up recently, and the board did decide to do that. But usually when we're trying to establish a neighborhood pattern, there's actually a pattern, not just a handful or the beginnings of it. And usually there's something in the covenants and restrictions that we've been allowing in the past that were generally giving us that latitude,
Yeah.
and kind of that inclination. Is there a pattern already? Is it a real pattern? Or
It is. I have driven through there, and there is a pattern that has developed with these. And I would hope that the covenants and restrictions did allow for that. It's just that when the development order, I think the development order was, and look at the plat, here the date of the plat was actually after the 1996 date, but it was 2000. Oh wait, that's Village at Blue Mountain Beach Phase 2. How did that get in there? Oh no, it is blue. Oh, that is the right one. Okay. Yeah. Okay. Yeah, that was 2004. It was just not a very well designed project.
I think this is also a circumstance, if I could, where covenants and restrictions were prepared that exceeded what the county allowed.
Okay.
Yeah.
So they had some square footage requirements as part of it from what was said?
I think they allowed these bump outs above the first floor
Okay.
that are slightly outside of what the county would typically allow. And specifically now, we don't allow those bump outs without a variance.
Right.
Previously, I think builders were bringing in plans that matched the parameters of what we would allow on a balcony or other type intrusion into the setback above the first floor.
Okay.
And then they just started closing them in and creating additional conditioned living space.
Okay.
And for some period of time, the county was allowing that without requiring a variance. But we've recently gotten a little more restrictive as far as how we read the code.
That interests me. You previously allowed it. Can you not continue to do that without having to go through this process?
No, sir, we cannot.
No.
They could if they so choose to, they so choose not to.
The county attorney has strongly suggested we read the code as written. And the code as written says the Board of Adjustment gives variances.
Did we not discuss, though, is there some way, I don't know how many more buildable lots we have, but is there some way that we can just make a ruling?
We've talked about doing that. I think we actually have done it in one neighborhood. Is that correct?
We've done it on 2 subdivisions so far. These, I guess, we have to have them call out the specific lots that are that size.
Would staff have any objections to doing that?
But we couldn't do that today.
No, I'm just,
We don't, but in this particular case, we don't have all the lots identified that might
gotcha.
Yeah, I think it would have to be
qualify for this.
subdivisions.
It's gotta give us something
Yeah,
to
because
do.
White Village and Whiteville.
I just think it's so
That
silly.
was, that.
You don't wanna come to
Get something
Jordan?
with some meat.
You don't wanna get together?
So Mac, you do feel that there are something in the covenants and restrictions that we're addressing documents?
I think so.
The staff would have not been just approving them willy-nilly. They would have had to have some reason to.
Well, there was some period of time where the county, if your covenants allowed it, then we would allow it we would allow your building plan to match your covenants. And then since then we've been redirected on that, and that we may not have quite the authority we thought we had to allow that in the past. And
Thank
so
you, Mr. Davis.
we're now bringing them to you.
That's a good point, though, because back in the, when we, the county, you know, when they did do that, that was back when, and I'm not gonna point fingers or anything, but people were doing right. And then as the economy boomed, you know, things just kind of went downhill and got taken advantage of. And that, you know, that's what at least that's the way I look at it.
Well,
Or the county staff got taken advantage of from the developer.
And there's no other
That's the way I
place in the law that I've ever heard where a private contract can vary an ordinance or a statute. It just, and covenants and restrictions are nothing more than private contracts between developers and future homeowners. Period.
The ones that was written previously does not change.
It doesn't give
So
it-
the ones that's written afterwards surely can't change.
It doesn't give any vested right to, you can't by contract violate a statute.
Right.
Now, we have the frequent circumstance of where the covenants matched the development order when the project was developed, and then it got turned over to the HOA, and they decided they wanted something different and just did it. Because the covenants are not a party involving the county,
Right.
or the county's not a party to the covenants.
Thank you, ma'am.
Thank you.
Do you want to come back, add anything? You good?
You just need some help.
Motion to close the public discussion.
So moved.
Second? Discussion? Vote? Wait a minute.
Motion to approve.
Motion to approve. Discussion?
Oh,
You might check.
We waiting on Jared to get called up.
Yeah.
Tammy.
Tammy.
No, I second your motion to
Right.
approve. I did.
No, Mr. Fletcher made the motion, Tammy made the second.
Yeah, my bad.
We got a motion, we got a second. Discussion? Tony? No discussion?
That was not a whole lot discussed. I mean,
Well-
you know, if we could subdivision specific blanket it is fine, but I agree with Mike and Vivian in this particular case we can't. I don't think we can. We need to.
I have some concerns
need
that
more of them.
the covenants and restrictions were probably taking advantage of. I think that was meant for balconies and maybe decks. And I think it's now extended to be the whole building. So I have some reservations. We had granted it. There's history on the board of allowing this particular neighborhood. I just put against the last one, so I don't know if it's excessive. And I do have concerns in the whole community because I think it's one of those words that will take advantage of. But it will be better for the community if those houses do have a living room. So I think we have benefit the argument is that it can't be. So in this particular case, I think it would be okay.
Very good.
Strong supporter.
Charlie?
I think it's okay with me. I got some comments.
We have a motion, we have a second. Well, we gotta close the discussion. You want me to close the discussion?
Yes, sir.
You making that motion?
I'm making that motion.
Can you second it? All in favor, aye, close the discussion.
Aye.
Aye.
We have a motion, we have a second. Tony, how do you vote?
Oh, come
You can,
on. Aye.
Aye.
aye. Scott?
Kind of cross on
Scott's an aye.
No.
This is moment with sun.
Charlie?
Aye.
You received your variance request.
Thank you.
Thank you for coming. We
Oh,
appreciate it.
I'm sorry. I have one more announcement. Probably, we're not sure of the date yet, but you'll be getting an email from us about an opportunity for public records, sunshine law, and ethics training that we're going to be providing all the boards. Just look for it. Not sure of the date.
There's nothing.
Sure.
We have, at this time, we will, Scott, are you good? You got all that? No, I'm talking about you, you're done. At this time, we need to elect a vice chair. I'll open the floor up for nomination for vice chair.
I'll nominate Tony. You're free to, you're free, yeah. Thank you.
Thank you.
I did. Yes.
Any other nominations? Close, motion to close it.
Motion to close.
Second. All in favor, aye?
Aye.
We have,
New vice chair.
we don't have to vote on it? We got to vote on it. We have a nomination for Tony to be the vice chair. All in favor, aye? Opposed? He's the vice chair. Thanks. Minutes. Has everyone had the opportunity to look at the minutes? Motion to approve. Motion to approve. All in favor, aye? All in favor, aye?
Aye.
Opposed? And let's see. That's all the business we need, is that correct? We don't have nothing else? Motion to adjourn.
So moved.
Second.
All in favor, aye?
Aye. Thank you, Mark.
See you, Mark. Be good, bro.
I second it.
She seconded everything.
She's our champion seconder.
Champion secretary. Have you heard from Art since he moved?
Hey, do y'all have his phone number? Yeah. His cell? Cause I'm the one he gave me doesn't work. When's the last time you tried it?
Since I read his letter to Heather.
He's probably changed it then.
You think he would? Because I was going to say,
I don't think he changed.
that's a good letter today.
I hear about his letter to the editors.
I mean, he hit the nail on the head. I mean,
He does, he does it well.
he did.
He's a talented guy.